Yes, legal representation of animals. That's my topic, that's my field of interest, most of all at the moment. And I'm going to make a suggestion here to you to consider an Aarhus Convention for Animals. Some of you will know already what the Aarhus Convention is, but I will get back to it and elaborate later. But that will be in the final part of my presentation. So this is an overview. I have 3 steps that I will take you through. First, I will discuss the significance of legal representation of animals. Why is it important? Raphael and Sean have already touched upon it, but I will do it in my way, so you get my version also. I have a couple of examples illustrating the significance. I will go a little bit into detail with those examples. I hope that will be beneficial. Then I have a short overview of existing approaches in different jurisdictions, how to deal with this problem of legal representation of animals. And then lastly, I will get to this idea about an Aarhus Convention for Animals. I should note from the outstart that my examples and my focus will be on farming animals, livestock animals, not because other animals do not matter, but this is where I see the biggest problems, the biggest challenges that we are facing, and the number of animals that suffer in the farming industry is enormous. So this is where I have my focus. But most of my points will also be relevant with regard to other kind of animals that human beings interact with, test animals, companion animals, zoo animals, and so forth. I should also say that maybe some of you, those of you who are not from Europe, will find this a little bit Eurocentric in my presentation, but that's because this is the law I know the best. I hope that there will be colleagues from other continents that can tell more about the situation in those jurisdictions. Anyway, here we go. The significance of legal representation of animals. Why is it important? Well, I think that when you look at legislation across jurisdictions in Europe and also in other parts of the world, the Animal Welfare Acts are very ambitiously worded. If actually that the Animal Welfare Acts were enacted and enforced according to the wording, we wouldn't have these problems. We probably wouldn't be sitting here because really they are very ambitious. And even on constitutional level, we find a lot of provisions that demands that animal welfare, animal protection is taken into consideration in legislation and administration of the law. So why is it not happening? Why is there this enforcement gap? To understand that, I think we need to look at the legal representation of animals. And why? Well, first I would mention that it's not a question of changing the substantial law when we look at the legal representation of animals. It's the procedural rules. It's to ensure the legal representation of animals. And why is that important? Well, first of all, it's a way of ensuring that animals have a voice in law. So, in litigation, we have always 2 parties. We have a conflict between 2 parties. And the judge has to adjudicate the case, listening to both parties. Even in penal cases, that's often the case. We have, of course, the prosecution, we have the defendants. We have the 2 parties, always this conflict, but we also often have a victim, so that the victim is present, the victim has a voice. When the victim is an animal, the animal is not present. There's no voice of the animal, it's an abstraction. So by ensuring a legal representation of animals, we help animals to actually have a voice in the courtroom. Now we saw the donkey before, and usually I like that picture because the donkey is there. And the donkey was convicted, maybe because the donkey was present there. I don't know. But it is important that the animal somehow, if not physically is present, then at least has the voice to speak up for the animal. So therefore, legal representation of animals is very important, I think, to achieve justice. And we will also ensure that the principle of equality of arms is maintained. So we have one party on the animal side, and we have one party on the human side that can speak up on equal terms. And I think this is important. We have some judges present here over the weekend, and I've been a judge myself. And I think as a judge, you know the significance of wanting to give justice to the parties in front of you. When you have a farmer who has not looked after his or her animals properly, you still might have, or you will probably have this understanding for the farmer situation. The farmer will talk about the wife has left and has lost control of everything and it's all gone wrong, and as a judge you will feel empathy and you see this human being in front of you. And when it's the animal cases, we don't have the animal on the other side. So it's not equality of rights. We have only one party to whom we want to give justice. And it's important to notice that this is relevant with civil litigation and administrative law and criminal law. I think that depending on the jurisdiction, it might be different what part of law is most important with regard to animal representation. In Denmark, criminal law is very important because this is the main avenue for ensuring that the animal will. The judge has to adjudicate the case, listening to both parties. Even in penal cases, that's often the case. We have, of course, the prosecution, we have the defendant, we have the two parties, always is conflict, but we also often have a victim, so that the victim is present, the victim has a voice. When the victim is an animal, the animal is not present. There's no voice of the animal, it's an abstraction. So by ensuring a legal representation of animals, we help animals to actually have a voice in the courtroom. Now we saw the donkey before, and actually I like that picture because the donkey is there. And Bernard, he was convicted, maybe because the donkey was present there. I don't know. But it is important that the animal somehow, if not physically is present, then at least has a voice speaking up for the animal. So therefore, legal representation of animal is very important, I think, to achieve justice. And we will also ensure that the principle of equality of arms is maintained. So we have one party on the animal side and we have one party on the human side that can speak up on equal terms. And I think this is important. We have some judges present here over the weekend, and I've been a judge myself. And I think as a judge, you know the significance of wanting to give justice to the parties in front of you. When you have a farmer who has not looked after his or her animals properly, you still might have, or you will probably have this understanding for the farmer situation. The farmer will talk about the wife has left and has lost control of everything and it's all gone wrong, and as a judge you will feel empathy and you see this human being in front of you. And when it's the animal cases, we don't have the animal on the other side. So it's not equality of arms. We have only one party to whom we want to give justice. And it's important to notice that this is relevant with civil litigation, administrative law, and criminal law. I think that depending on the jurisdiction, it might be different what part of law is most important with regard to animal representation. In Denmark, criminal law is very important because this is the main avenue for ensuring that the animal welfare standards are upheld. In other jurisdictions, there might be civil cases that are more important in that regard. Yeah. And as a point here I want to make, and for those who are not familiar with EU law, I'll just explain briefly what it's about. In the EU, to make EU legislation be applied in a similar manner in all EU member states, we have this principle of preliminary references. That means that the judges, they have to refer questions on the interpretation and application of EU law when it arises in national cases. So this is really important to give EU law a power and to ensure that it's being applied in the same manner across jurisdictions. So if you don't have cases on animal law before the courts, and if there's nobody speaking up for the animals, it's very unlikely that there will be references made to the Court of Justice of the EU on the interpretations of animal law. That means that the EU legislation on animal law doesn't develop in the same way that other legislation develops. So therefore, it is really important when we talk about the EU and its rules that come from the EU system that we have this possibility of preliminary references. So therefore, for all of these reasons, I think that it's very important to look at the legal representation of animals. Okay, as promised, 2 examples, just to make it a little bit more concrete. So the first example, it concerns keelbone fractures among egg layers. It's a big problem. It's more or less the same kind of hens that are being used as egg layers around the world. And a study from Denmark, a recent study, shows that 85% of all egg layers, they suffer 1 or more keelbone fractures. It's very painful for these hens. Why does this happen and why has it increased? Well, it's because of the hen size. The hens are getting smaller when they don't eat as much. It's the age of onset of lay. It's getting younger and younger, so we get the production going as quickly as possible. And it's because of the size of the eggs, the weight of the eggs. There are also other reasons, but these are some of the major reasons for this problem. Well, what do we have? What kind of litigation is relevant in this regard? Well, there's this EU directive concerning the protection of animals kept for farming purposes. And this is a quote. I suppose a lot of you are lawyers here, maybe all of you. I'm not sure, but I hope that you're not too unfamiliar with legal text. So therefore I've quoted this so you can see for yourself. And it says, no animal should be kept for farming purposes unless it can reasonably be expected on the basis of its genotype or phenotype that it can be kept without detrimental effect on its health or welfare. So, how can that work together? How is this possible that we have this situation with egg layers when we have this legislation? This has been transposed into Danish law, same wording. So this is part of Danish law. This is a ministerial order. And on top of that, we have the Danish Animal Welfare Act, which states that animals must be protected best possible against pain and lasting injury. So, yeah, there's a problem here. And for that reason, the Danish Vegan Party, at that time it was eligible for parliamentary election, they actually notified the police about this situation. Again, this is the way we can deal with this in Danish law. You cannot initiate civil litigation on a case like this. It would be turned away from the courts. There's no concrete decision you can disagree with. There's no administrative decision that you can deal with here. You just have something that goes on, and well, the police really should interfere with this and uphold the law as we see here. At least that's what with the Vegan Party they thought. So they notified the police, but the police declined to take the case further. If anybody is interested in the reasoning behind this, we can take that later. I think it's a quite interesting case. Anyway, my point here is that it was the police prosecution service that was trying to, or had to consider whether to go on with this case. And when they decided not to do it, there was nobody who could complain about that decision. Now, if it had been a human victim, there would have been the possibility of appealing this decision by the police not to press charges. But because it was animals, the vegan party, they would not be able to do so. They were not victims in the case. So the case ended there and then. And again, if it had been possible to go to the courts, then the court probably could have made a preliminary reference to the Court of Justice of the EU, enabling us to get the Court of Justice's view on the interpretation of this directive rule. And of course, it would have possible consequences also with regard to other kind of animals, milk cows, big issues there with whether they are fit really for being farmed the way that they have been bred and so forth. The other example is tail docking of piglets. In Denmark, we have a yearly production of approximately 11.5 million animals in the pig industry, and 99% of them, they are being tail docked without the use of anesthesia. Again, I want to quote an EU rule for you. We have a directive on minimum standards for the protection of pigs. And there it says that neither tail docking nor reduction of corner teeth must be carried out routinely, but only where there is evidence that injuries to sows, teeth, or to other pigs' ears or tails have occurred. Before carrying out these procedures, other measures should be taken to prevent tail biting and other biases, taking into account environment and stocking densities. For this reason, inadequate environmental conditions or management systems must be changed. So that's why pigs, they bite each other's tails. That's because they're not being stimulated enough, because the environment is not adequate. And therefore, this rule, I think, is very reasonable. So, but how is this possible how is it possible that 99% of all these piglets are tail docked when we have this rule? Well, in Danish law, we have still the Danish Animal Welfare Act. I told you before, it states that animals must be protected best possible against pain and lasting injury. These piglets are losing their tails, and treated with consideration, including housing and care with regard to their physiological, behavioral, and health needs. So already here we see there's seemingly a discrepancy with the real life situation. Well, we also have a Danish rule that transposes the EU directive, and it permits tail docking of piglets within the pig's second to fourth day if there's written documentation that there has been damage to the tails. Formal requirements of risk assessment and an action plan is also encompassed in the Danish ministerial order. So, as a citizen, I'm curious whether this actually is in accordance with the Animal Welfare Act. When the minister made this ministerial order and this rule, is that coherent with the Animal Welfare Act? Is it a proper transposition of the directive? I doubt it, but I don't know. And I will never find out, because I cannot challenge this. And nobody can challenge this. Nobody has the legal interest required to do so. And again, we will not have the possibility to have preliminary ruling from the EU Court of Justice. So, Yeah, just some examples illustrating the significance of this topic. I'll do this very briefly now. The main approaches in non-European jurisdictions to this problem, well, there have been attempts at achieving legal standing for animals. And Raphael, he just showed the timeline. It's an ongoing thing. And for example, the Non-Human Rights Project, Stephen Weiss and those guys, they're doing a tremendous job there. Maybe not achieving so very much until yet. There's particular focus on habeas corpus cases. Of course, this is a significant step. It's a kind of a bridgehead, if that can be established. But it's a long way to being able to challenge those kind of problems that I mentioned before. So these are very good for what's being done here. I fully support it, no question about it. But I think maybe there's a need for other approaches as well. There have been some notable successes, though, also in this regard, and there we have some of the cases we're going to hear about from Argentina, the Celia case, Estrelita from Ecuador, and then we have the Nagasatsu case from Islamabad, of course. So development is happening there, but I think there's a need for other approaches as well, especially outside the common law tradition countries. One case I want to mention is New Zealand. There, animal welfare organizations that have been successful in challenging general administrative regulation concerning the use of farrowing crates for sows. For me, that's an interesting thing also, because this is exactly the problem that I identified before. The coherence between administrative regulation and the laws behind. So that's what these New Zealand Animal Welfare Association was successful in challenging. In Europe, continental Europe, well, in 8 German federal states, there's a right for NGOs, animal NGOs, to challenge administrative decisions, Verbandsklagerecht. In the canton of Bern, the umbrella organization of animal welfare organizations, they are authorized to lodge a complaint against decrees, Verfügungen, and decisions in the field of animal welfare. Whereas I'm not sure about the exact limits in Germany. It also depends on what federal states, because we have 8 different federal laws on this. So it's very nuanced. What kind of decisions can be brought before the courts or can be appealed against? So whether you can bring an appeal against or complain about a ministerial order or not, I'm not sure. But I think in the canton of Bern, when you read the wording of the provision, I think it indicates that you can do so. And then in France, there are some rules in the Penal Procedure Code about the possibility of animal welfare organizations to become civil parties to criminal law cases, claiming damages. So also then obtaining some kind of legal representation of animal interest in those cases. I will not go into detail with this, but I can suggest that Eva has co-authored an article where you describe these rules more in detail. In Austria, they have an animal welfare ombudsperson in each region. That's another way to deal with this problem of lack of representation of animals' legal interests. Okay, and now the clue. Okay, just 2 minutes. Yes, 2 minutes. Okay, so very quickly, where are there other avenues and other different approaches to deal with this problem? I think to look at the situation with environmental law is very fruitful. the environment doesn't have a voice, nature doesn't have a voice, so it's a kind of similar kind of problem. And there we have the Aarhus Convention. It's a convention under the United Nations Economic Commission for Europe. And then there are three pillars: access to information, public participation in decision making, and access to justice, environmental matters. And I think to have something similar with regard to animals would be very, very interesting. Maybe not one-to-one the same. For example, public participation in decision making, I'm not sure how that would work. But in particular with regard to access to information and access to justice, this might be a way to ensure a voice for animals in law. No new substantial rules will be required, only procedural rules. And it will ensure a level playing field across jurisdictions. That no substantial rules will be required, I think, should make it easier to persuade decision makers, politicians, that this is a good idea. It's not a question about restricting the use of animals in any certain way. It's just to give animals a voice and give more force to the legislation. What's not to like? And it will be across jurisdictions if it's an international convention that would obligate all the participating countries. Each jurisdiction may rely on existing procedural law and so forth. What international forum? Well, it could be the UN forum, the Economic Commission for Europe, for example. They already got the Aarhus Convention. They know how to do that. There's a framework for that. It could be copied. It could also be the Council of Europe. We have several animal protection conventions under the Council of Europe. So they have engaged with animal welfare and protection before. So you could envisage that it would be natural for the Council of Europe to then see how these conventions can be made more stronger and actually be upheld. Yeah. So that's to consider. EU, I think maybe not so much, because there will be economic consideration taken into account and so forth. It will be cleaner, so to speak, in the UNECE or the Council of Europe. And how to initiate the process? My very last sentence, Raphael. Well, by coming here telling you about this, there will be a need for academic work in this field. I myself hope to be able to make a comparative legal study to get more insight into the similarities of how they are, how this problem is being approached in different jurisdictions. But of course, it's also a political question. So it will be a question about engaging with politicians on European level, on national level, and so forth. But let's start today, and I hope that some of you will find this interesting. Thank you very much.